Well, thank you very much. I think Martin Luther King once said when he was being introduced, they said some things, and then at the end he said, I do not know whom you are talking about. And I think this is exactly what I'm going to say regarding the kind remarks that were made. But having all said and done, I really feel privileged and honored to have been asked to come and share a few thoughts with you on the subject for the discourse today. I normally like starting on a light note. In Lesotho, I'm informed by one of the judges that there was a client with his lawyer. This man was apparently a recidivist when it comes to stock theft. His name was there in the books of stock theft for quite some time, and he had been awarded a sizable number of fines and custodial sentences. So this one day, having been charged, he appears before the magistrate, and when they go through precognition and they are preparing for court, the lawyer delivers the bad news to say, sir, today I think you are going in. There's nothing that I can do for you. So he then says the only thing that you can do is once the case is called and the charges are read to you, you just feign insanity. You pretend you are insane. Maybe that will get you off the hook. So they call the name, and then he starts shouting, Nancy Ndaba, Nancy Ndaba, and the magistrate, gets worried. What is wrong with this man? And then he says, no, you go home. When you are sane, we'll call you back. So they walk together back to the lawyer's office, and the client is patting the lawyer on the back. He says, you are great, man. Today I saw myself there, but you have yanked me out. And then he says, so then the lawyer says, no, the job has been done, so I need to get paid now. And then the client says, Nancy Ndaba, Nancy Ndaba. He starts shouting again. And then he says, no. That was for the court. This is now between us. And that is how he did not get his money. So he counseled his client to do something. What was supposed to be a shield turned out to be a sword. Now, coming to today's topic, I've been asked to speak about the core values of judicial office, the relationship with legal practitioners, and the conduct of judicial officers in court. Let me start by saying, what do you expect of me today? Because I do not want us to work at cross purposes where I come and dish a meal, and the people say, no, not this, not that. Just to get a sampling of what you expect to get from today's lecture. I have absolute rights to pick and point at people. So I want to make this clear right from the beginning. What do you expect to hear from today's lecture or to learn? Ms. Shomani is perfectly excluded. She's my assistant, so she has some immunity of sorts. Oh. Sir.
Maybe how a presiding officer should interact with the court staff, including the legal practitioners.
Mm-hmm. Yes, that's one. What else? Ma'am?
I don't have any expectations other than,
No, you should have expectations. If you don't, then you can go home. I'm joking. Yes, ma'am.
Just ethics in general.
Ethics in general. What ethics?
Ethics expected of a judicial officer.
Judicial ethics. I see. Yes. Okay. I've heard what you expect. It is not out of line with what I have prepared. But what I want to say is that you must count yourselves very fortunate for the reason that you have this opportunity to maybe get training. I was a legal practitioner in Swaziland, and I'm not going to tell you the year. I do not intend giving out my CV. But on a Friday, I was appearing in motion court. I was then in private practice. The following Monday, I was sitting on the bench. I was expected to do cases sometimes with people who were senior to me. Some of my colleagues we were with at university. It was literally a jump to the deep end of the pool. And there were two choices, either to sink or swim. And the most likely, almost inevitably, was to sink. So where you have an opportunity to be prepared about what you are going to meet, even before you get to the bench, I think is a very, very big plus. So we should give a round of applause to the insight and foresight of our judicial authorities by doing or by carrying out this type of training. It is very, very important because the transition from being a legal practitioner to being a judicial officer is not very easy. One of the meals that you have to prepare, in fact, I compare judicial work, particularly delivering judgments, with preparing a meal. How do you expect someone who comes from being a legal practitioner to suddenly be able to serve a meal? Not just a meal, that's one that is well prepared, all the ingredients are perfectly balanced, and it is palatable. Whether it is right or wrong, maybe is not the issue. So I think with all the training that has been placed at your disposal, I should count you very, very fortunate. Now, how I want to deal with the paper is as follows. I want to deal firstly with the definitions. There are some words that come out clearly, the word values, the word ethics, and then I will go on to deal with the issues as they come in turn. I'm told of a young man who was sitting with his father, and the father asked him, "Young man, what is a screwdriver?" The boy knew a screwdriver. He knew what its purpose was. But when he had to define what a screwdriver is, he suddenly hit a cul-de-sac. So he thought long and hard, and then he decided, Dad, a screwdriver is what drives screws. That was the simplistic and common sense answer. So I do not want to find myself in such a position where I will be saying, a screwdriver is what drives screws. So this is where I want to start with the definitions. The first word I want to deal with is the word values. What are values? And I will enlist your assistance. What are values? Because in terms of the paper, we're supposed to deal with what are the core judicial values. What are values? There may be no correct answer as such. And sometimes the answers that you give may then give us the whole perspective and full measure of what values are. I like us to be interactive. The Oxford Advanced Dictionary describes values as, quote, beliefs about what is right and wrong in life, unquote. But in the context of the paper today, I would say that these are the high standards and principles of behavior to which judicial officers, by virtue of their office, are expected to adhere to and be guided by in the performance of their official duties and in their lives in general. So this is not only about what you do when you sit on the bench. I think judicial office extends beyond the bench. You cannot just sit on the bench and follow all the values that are expected of you on the bench, and then when you leave like a pig. let me use that word, and say, I'm no longer judging now. I can do whatever I want to do, however I want to do it. Those values, it's when I'm sitting in court, wearing my gown and my bib, then there I behave like a judicial officer. And then when it's 5 o'clock, it's my time. I do what I do, when I do it, how I do it, wherever I do it, and no one is going to call me to account. It's a 24-hour life. There are no breaks. I'm not saying that you cannot have a life of your own. You can, but however you live your life, it must not have a negative bearing on your judicial office. Because when people see you, they see a judicial officer. I remember once in Swaziland, I come from Swaziland, by the way, that kingdom, yes. So I met one of the ministers whom I knew very well. So he hugged me and we greeted and he said, today I took the law into my own hands. Aww. And then I thought, this is how some people look at judicial officers. When they see you, you are the embodiment of the law. When he hugs me, he tells me, I took the law into my own hands. So I think this is the perspective that we must have about how people look at us, what people expect of us in terms of our behavior, in terms of our life, and then in terms of our application to the work. I'm already preaching, and it's fine. I was just dealing with the word core. And then, I dealt with the word values. And then when we deal with the word core, to me it means that which is germane, that which is important, that which is at the center of the judicial office, and to which every judicial officer must, as of necessity, adhere. And without doing this, it means that you cannot properly and efficiently perform the exalted duties and functions of the judicial office. So those are the core judicial values. Now, I want to go on and mention that when we talk about core judicial values, and this is what I want to deal with now, there are many sources from which we can find what the core judicial values are. Would you be in a position to mention some of them? The Constitution of Namibia. Yes, that is one. The Code of Ethics. That's another. Mrs. Wakatama. The Bangalore Principles. Yes, we will deal with those ones. What else? Sometimes even judgments. There may be judgments which speak particularly of appellate courts, which speak about how a judge or a magistrate behaved in a certain manner or matter. Those can be some of the principles. Well, I now want to deal with these principles in turn. And I want to zero more importantly on what are called the Bangalore Principles of Judicial and Ethical Conduct. And these are applicable, I think, internationally. In every jurisdiction, this is what is referred to. And if you look at our own Code of Judicial Ethics, a lot has been drawn from the Bangalore Principles. So if we deal with them, we will have, in a sense, dealt with what obtains in Namibia. The first principle I want to speak about is that of independence. What do we mean about by the word independence? The ability not to be influenced, particularly negatively. Yes, what does someone else say? Because the word to me has two aspects to it. Independence, which means you must not be dependent on something, but there must also be something on which you are dependent for you to be independent. Am I right? Is there anyone who disagrees? You are able to disagree. And here we are lawyers. There may not exactly be a correct point, but we are here to share ideas. I think that's what it means. Because you should not, if you are independent, you cannot be independent but not dependent. Which means when we speak about, and that, I think it goes back to what Ms. Mokomele said, which means there must be no negative influences which affect your independence. But there are other things on which you must be dependent. For instance, judicial virtue of office, propriety, all these other things. Even your own character. There are things that you must be dependent, because you cannot be independent and just, hang in the air. No, it cannot be. You are independent, which means you cannot be negatively influenced, but there's something on which you must be dependent, which will assist you as you carry out your judicial office. Does that make sense? It means when we talk about independence, we're speaking about not being dependent, but also being dependent on something that is good, on something that is virtuous, on something that is solid. And then once you are dependent, you will be independent. Am I contradicting myself? Is there any question on this one? Okay. Our constitution in Namibia, in Article 12, provides as follows when it speaks about a fair trial. It says that in the determination of their civil rights and obligations, or any criminal charges against them, all persons shall be entitled to a fair and public hearing by an independent, impartial, and competent court or tribunal established by law. End of quote. In this section, or in this article, there are at least 3 core values of judicial office that appear. There is independence, there is impartiality, and there is competence. But for now, we're dealing with independence. The Bangalow principles say the following regarding judicial independence. They say that judicial independence is a prerequisite to the rule of law and a fundamental guarantee of a fair trial. A judge, and when I speak about judge, at any point, you can paraphrase it and say judicial officer, because I do not want a situation where, no, the judge said this applies to judges, I'm a magistrate, so it does not apply to me. No. When I say judge, I mean judicial officer. So let me read. A judicial officer shall therefore uphold and exemplify judicial independence in both individual and institutional aspects. There is a case from Canada which speaks about judicial independence, and it's the case of Valente versus the Queen. My paper will be distributed, the citations will be there. But there, the judges drew a distinction between what they called individual independence and institutional independence. Speaking about judicial independence, this is what Mr. Justice Ismail Mohammed said in an ICJ conference. He says that the independence of the judiciary is crucial. It constitutes the ultimate shield against incremental and invisible corrosion of our moral universe, which is so much more menacing than direct confrontation with visible waves of barbarism. Subvert that independence, and you subvert the very foundations of our constitutional democracy. Attack the independence of judges, and you attack the very foundations of the freedoms articulated by the Constitution to protect humankind from injustice, tyranny, and brutality. End of quote. I told you I come from a kingdom, and I've had my brushes when it comes to issues of judicial independence. In 2003, I slept on a Wednesday as a judge of the High Court. And the following morning, there was an instrument signed by the King of Swaziland, which was transferring me to the industrial court. In Swaziland, we have an industrial court, which is, in South Africa, they call it the labor court. I was not consulted. No one asked me a question. And there was just nothing, just that instrument. And when I later learned, they said my judgments are not palatable in the High Court. So they wanted to move me to a court that is less political. That was the explanation given. So I challenged that. So for 9 months, I wasn't going to work. I mean, I was going to work every day, but I was not given any cases to do. Because what you should understand is that when you're a judicial officer, so many people rely on your independence. The state is powerful. The state has money at its disposal, and the state ultimately is the one that employs judges, in a sense. But you are not an employee of the state. You are a servant of justice. You are there to ensure that you do what is right, what is in accordance with the law, and your master is not the president, not the prime minister, but your master is the law. You have to do what is consistent with the law, what is consistent with justice, and more particularly with the constitutional imperatives. That was my first brush. And then when again, in 2011, there are cases that I dealt with which were really, really unpalatable. Maybe in a republic, things are much better, but in a kingdom, there is one person who's in charge. And once you are seen to be making decisions which are unpalatable to him, so many things may happen. But as a judicial officer, you have to stand up strong and do what is right, do what is correct, regardless sometimes of the consequences. Because so many people depend on your independence as an individual judicial officer. When we speak about judicial independence, I say that there is institutional independence and there is individual independence. What do we mean by these two terms? What is institutional independence? Okay, there is a judge called Lord Neuberger of Adsbury. He was the master of the rolls in the United Kingdom. This is what he says about individual independence. Individual independence refers to each judge's ability to decide any part of a case by applying the right law to the right facts. Judges must be independent of the parties and must not be subject to any pressure or inducement from the parties, and must be open-minded and impartial in their approach to issues. He continues when he speaks about institutional independence. He says, institutional independence goes wider than individual independence. It refers to the constitutional principle that the judiciary is independent from the two branches of state, that is the legislature and the executive. It is the constitutional principle that the judiciary cannot be properly influenced by the executive or the legislature in carrying out the judicial function. And I like this part. He says influence, whether overt or covert, undermines the judge's ability to decide cases on their merits. And I like this more. Justice under the influence is no justice at all. It is inimical to the rule of law and our democratic system. When we speak about institutional independence, for instance, in Namibia, we have now the Office of the Judiciary. About individual independence, that is you as an individual. There is no other person. You are sitting, you are dealing with a case alone. What do you do? That is the test of individual independence. Some people say you need both institutional and individual independence in equal measure to succeed. In my view, the most important is individual independence. Does anyone differ? Because you may have all your colleagues. I've had colleagues who ran away from me. When the stakes were high, people did not even want to speak to me. My colleagues, speaking to me was like speaking or touching someone with leprosy, because the executive were looking at who speaks to who. But this is where, in solitude, that is where you display individual independence. And this is what every person of sound mind will appreciate, that this is a judge who stands for the truth, who is not swayed by the stakes that are put either on his life or in his career, but is there to ensure that justice is done at all costs, even for the weak, even for those without money, even for those who are impoverished, even for those who are vulnerable. That is where a judicial officer should come out. In Swaziland, we had a very, very trying cases in terms of judicial independence. We had a Chief Justice who was in charge of, and in fact, there is one thing that I must mention. When we speak about judicial independence, we are not only speaking about independence from the executive and from the legislature. There may be powerful, people in the business sector. Oh, Judge, there is X and Y company. We are hosting a dinner. Please come. And the next week, there is a case in which you are presiding. So they want to control you. So these are things that, as a judicial officer, you must be very, very careful about. And then also, and more importantly, you also should be independent from the leaders of the judiciary. I have seen a Chief Justice ruining a whole judicial institution. That happened in Swaziland, where the Chief Justice would tell you, oh, it first starts with allocation of cases. Who is here? So and so. That judge is not going to give a good judgment. The one that we want. No, the one that they want. And they told me they want. So this one, this one, yeah. So from there, the case is then allocated to you, not because you are the most capable, not because you are the brightest, not because you are the most principled, but because they want a certain result from you. And if you deliver it, you are going to rise. I used to be a law lecturer in my younger years at the University of Swaziland. I was doing part-time lecturing. And some of my students are now judges, my former student. One of them was the registrar of the High Court in Swaziland. And when I was removed from the bench, he signed the affidavit that got me removed. And for doing that, he was rewarded with a post on the bench. And he had the shortest tenure as a judicial officer. He was a judge for 2 years. After that, he was impeached. Early this year, he was removed from judicial office. What did the Chief Justice do? The Chief Justice had a case against the Revenue Authority. This case started whilst the registrar was still the registrar of the High Court. And the Chief Justice wrote letters which were signed by the registrar contesting his tax liability. And he sent this registrar to go and argue his case with the revenue authorities, unsuccessfully. So when the Chief Justice then decided to take the position that he's going to sue the revenue authority, he appointed this fellow, and this fellow presided over the Chief Justice's case. After that, he was then impeached for dealing with a case in which he should not have. It was unethical for him to sit in judgment over a case in which he had participated in another capacity. And that is what cost him his judicial office. What am I speaking about? leaders of the judiciary putting judges under pressure to do what they are not supposed to do. So when we speak about judicial independence, we're not just speaking, I must emphasize this, we're not speaking only in terms of the executive and the legislature, but we are also talking about judicial colleagues. There is a case that Judge Mokomele is doing. And then maybe I know the other party, then I, Judge Mokomele. No, I think this is how this case must go. I do not disclose to her that I know that other person. As much as judicial colleagues, we discuss matters, but ultimately, you must be the one that makes the decision. You can hear what colleagues say, you can hear how they approach issues, but ultimately, the decision must be yours. You must be able to sleep soundly, knowing that you have made the right decision. No one has influenced you. Let me repeat. Justice under influence is no justice at all. Even if it comes from judicial colleagues, even from those in charge of the judiciary, you should not bow. In relation to that issue, that very young man, my former student, there was someone who sued the king in Swaziland. It was an owner of a guest house. So what happened is that the king took one of his concubines to live in that guest house, and apparently rent was not being paid. So the bank started knocking and they wanted to foreclose on the bond. And then when he sued the king's office, the registrar, the chief justice drafted a letter for the signature of the registrar to say that you are now suing the king has immunity, we are not going to accept your summons. And I took the phone and called the registrar. And I said, Mr. Registrar, where do you get powers to refuse to accept summons? And he said, no, the Chief Justice said. I said, but what law did the Chief Justice cite that gives you a right as a registrar to refuse to receive and endorse and issue summons? And I got no answer. But what eventually happened is that the Chief Justice then issued a practice directive to say that no cases directly or indirectly affecting the king shall be received by the courts. When the issue of whether the king has immunity or not in any case is a judicial decision, in terms of which the case must be registered, and if the king's office wants to raise the issue of immunity, the court must sit down and declare that in this case there is immunity, in this case there is no immunity. And I told him, I said, sir, this Chief Justice is a national of Lesotho. He will leave you alone one day and you will be stewing. I said, in Swaziland, things changed. One day, the people whom you've been preventing from coming to court, you'll find that he has been appointed the prime minister or the minister. And the first thing they will do, they will institute an inquiry. And you'll be alone, the Chief Justice will be gone. What happened? This young man was arrested for defeating the ends of justice, and he went to, I don't know how many days he was in prison, and he was later released, and ultimately, he was removed from the bench. So let the dictates of the law dictate what you do. If anything finds no support in the law, not even the highest office should be able to tell you to do A, B, C, and D, and you do it. Because ultimately, you will pay the personal sacrifice. They will not be there to share the burden with you. A man called Griffin says, judges in the United Kingdom are not beholden to the government of the day, and they have longer professional lives than most ministers. They, like civil servants, see governments come like running water and go with the wind. They owe no loyalty to ministers, even that temporary loyalty which civil servants owe. Coke said, the king is under no man, but under God and the law. Judges are also lions under the throne, but their conception of the seat is occupied in their eyes, not by the prime minister, or maybe in a country like this, not by the president, but by the law, and by their conception of public interest. It is to the law and to that conception that we owe allegiance. In that lies the strength and the weakness, their value and their interest. End of quote. There is a case in South Africa, economic freedom fighters against the Speaker of the National Assembly and the Democratic Alliance and the National Speaker of the National Assembly and others. I'm sure you followed it. The issue of over whether the president was bound by the findings, or what do they call it, of the public protector. Yes. When I saw the Chief Justice of South Africa last year at the Judicial Conference, I said to him, Chief Justice, I was really enthralled to read your judgment. You spoke about the separation of powers. You spoke about the rule of law. But you said nothing about the independence of the judiciary. You need not have said anything, because what you did is that you displayed judicial independence without saying one mumbling word. And that is what I liked about that judgment, because all those judges were appointed by the president. But when the stakes were high, they told the president, you are out of order. You have defied the Constitution of South Africa. So it does not matter who appoints you. Once you get in this car, no one will tell you where to stop or when to drive, when to open the windows. It must be the law that tells you what you have to do, when to do it, and how to do it. In Swaziland, they like this phrase, how can you bite the hand that feeds you? The hand that feeds you is the law. It's not the hand of a human being, regardless of how exalted the office of that person is. I'm sorry, I'm so passionate about judicial independence, because to me, it exemplifies everything about a judicial officer. Even if I can speak about it the whole day, that for me would be fine, because everything else ties into it. I will close maybe by quoting the words that fell from the lips of Mr. Justice Roger Warren. He says judicial independence has to be continually fought for and won anew each day. It is grounded in public interest for the courts and for the judicial function. Like respect, it cannot be demanded. It must be earned. End of quote. Last year, I was asked to speak in Botswana about judicial independence to the judicial officers there. And I asked a rhetorical question. Why must we spend money, fly to Botswana, book very expensive hotels, and speak to ourselves about judicial independence? Why don't we speak to the heathens? Because we are the converted. We are the Christians, when it comes to judicial independence. And then there are the heathens, sometimes the executive, all these others. And I said, why don't we go under the tree? Maybe there, what's that park? Zoo Park. And speak about judicial independence, because there may be many reprobate souls there who know nothing about judicial independence, who may actually be violating judicial independence or attempting to violate it. But then I came back and said, judicial independence is something that we need to keep preaching. So that, because once you become a Christian or a Muslim, you don't stop going to church. Say, now I eat the Sabbath, so I no longer have to go. You have to go to church every day. For your spirit to be cleansed, you read the word and you go along in your path. You must go from strength to strength. So it is. Because, the attacks on judicial independence, they take many forms and shapes at every level. Some of them are very subtle. So you need to know what is the latest on the latest trend in the attacks on judicial independence. So it is something that we must guard very, very jealously. It is the most valuable possession that any judicial officer has. And once you keep that locked away, but energizing you in your every move, then the judicial future is bright. Well, that one is a bit difficult for me to answer because I do not know what happens. Because interference does not come walking through the door. And everyone sees it there. Oh, there it is. It might be a phone call. It might be an invitation to lunch. I do not know what happened. And in other countries, judges go to court with cell phones. Judicial officers, they go with cell phones. When they're dealing with cases, a message will come. Convict, acquit. No, I'm serious. I'm very, very serious. And you give him so much. This is a decision that you must make. These are things that are real. And maybe another thing that I should speak about, which I'll come to your question, which affects judicial independence, is the emoluments of judges. Judicial officers must be well paid so that they do not fall victims of bribery and corruption. I met a judge, I can't remember from which country, one of the French-speaking countries. She told me that after hours, she goes and sells vegetables and whatever in the streets in order to augment her salary. So these are very real issues. But now, coming to the Kenya question, I do not know, as I say, what happened behind the scenes. But I see these two as different petitions. The first petition, and what I liked about the judgment of the Supreme Court of Kenya is that they displayed independence. The president threatened them. He even insulted them. But they stood up, and one of the main things about the Kenyan Constitution is that it has introduced electoral principles right in the Constitution, which underlines what are the important ingredients of what we should stand as an election. Most constitutions do not. And the Supreme Court escalated jurisprudence because normally what they would say is even if there have been irregularities, if they do not serve to affect the general result, you should forget about it. But now there are two things that have to be satisfied. One is the constitutional master. That is what the court said. The court said that if the constitutional principles have been violated, end of story. You do not even have to go and see how much effect that has had on the overall result. If the constitutional principles have been violated, end of story. But then in this particular case, they moved on and found that, in fact, the irregularities that took place did affect the result. So as far as that was concerned, I have no qualms. But I have not read their new, the new judgment. But I do not think that if you are a judicial officer of note, for you to display judicial independence is for you to be seen to be fighting against a politician. I heard about an accused person who appeared before a magistrate 5 years ago. And he asked him, "How old are you?" And he said, "I'm 25. He appeared the next time after 5 years. "How old are you?" "I'm 25. And the magistrate said, no, but the last time you appeared, you said you are 25. And today you say you are 25. He said, no, I want to be constant. I do not want you to think I'm changing my version. What am I saying? I'm saying that if you are independent, it does not mean that if you have found on the facts and the law that the presidential election was flawed, for you to display that you are independent, if the case comes up next time, there are new facts you must hold against the president. If the law in that particular instance says that the president this time is correct, you have to do it. I hope I'm answering the question. So as I say, it doesn't mean that judicial independence is when you find against the president. And as long as the presidents come and you are still on the bench, you must show consistency that yes, the president is wrong always. No. If the law is on his side and there is nothing that can be shown, then you are within your rights to change and give a judgment in terms of the facts of that particular case. So I haven't read the latest judgment, but the other one I read, and the others I read, together with Mrs. Wakatama. We shared those judgments, and they were very enlightening. No, you have to share. You have to share. You must read. This is one of the things that I am going to mention. So may I move on? The next one I want to speak about is impartiality. I might not be able to cover everything, but the paper will be distributed to you. It probably will have more than what I have said. Judge Edwin Cameron, one of the Constitutional Court judges in the Republic of South Africa, says that judges on appointment are not celestial virgins, which means that you know nothing, you perceive nothing. There are things that you go through in life, your religious beliefs, things that happen to you which tend to influence your outlook, your views, your perspective of issues, even issues that maybe come up on the bench. I remember in the year 2013, we were doing judicial training for judges under the auspices of the International Commission of Jurists. It was in Johannesburg in South Africa. There was a lady judge from Tanzania who was a Muslim. And she said, I can't deal with a case, what you call them, the lesbians and, yes, the gays and lesbians. She says, no, I can't deal with that. No. Judge Mohoro, who sits on our Supreme Court, was one of the judges. And she told her, if that is your view, please leave the judicial office and go home. One of the things that I've learned when it comes to judicial office is that you have to disabuse your mind of your own predilections, your own beliefs, your own whatever. Because the law might not always coincide with what you believe. And sometimes you write a judgment totally disagreeing with what you are saying because it goes against your own beliefs. But what we are looking for are not your beliefs. We are looking at what the law requires in a particular situation. It's very tough. But I have had to negotiate my way through that because, I have my own standards at home. There are things that do's and don'ts in my house. But when I go to the house of law, it is not what happens in my house that must happen. There are rules there to be applied, and I cannot impose my own standards on everybody else. So what I must do is to understand what the law requires, and then I must state what the law requires, even if I am bleeding inside. That goes against my own personal beliefs, my religious beliefs, my upbringing, and everything about me. I am talking about impartiality, am I not? That you must be impartial. You do not start imposing your own standards, your own beliefs on other people. One person says, and remember, impartiality we already referred to in Article 12 of the Constitution. The virtue of impartiality is one of the most important of all judicial values, and it is the most difficult to attain. I'm not speaking about conscious partiality, favoritism, or prejudgment, for no judge of moral integrity would be guilty of such an offense. No judge worthy of his office would knowingly permit his understanding or to influence his decision. It is precisely through blind faith that a judge lulls himself into a false sense of security. He has failed to take into account the limitations of human nature. He has overlooked the difficulty of bringing to consciousness hidden motives, ideas, and prepossessions. The partiality, the prejudice with which we are concerned is not an overt act, something tangible on which you can put a finger. An impartial judge does the following. It is the suppression of personal emotion, the willingness to suspend judgment until a comprehensive survey of the ground has been made, a hospitable receptivity to the viewpoints of others, a disposition, in the language of Justice Holmes, to learn to transcend our own personal convictions, a distrust of spontaneous conclusions of the so-called common sense or happy conjecture, unchecked and unverified by reflective thought and deliberation. All these play part in enabling us to approximate with a high degree of probability. That is all we can expect. Human nature being what it is, that is what modern science expects. Impartiality. I'm sorry, there is one thing I forgot to speak about when I spoke about judicial independence. You must also be independent from yourself. You must be independent from yourself. And this is what, there's an author called Shientag. You'll find that in the paper. This is what he says. The subtlest poison to which a judge may succumb may be from pressure within. Every man craves praise, although some call it recognition. A deep instinct of human nature is the yearning to be appreciated. Within the normal limits, that craving is not only natural, but also desirable. It becomes reprehensible when the judge woos popularity by his decisions or by his conduct on the bench. You listen to public sentiment. This is the way they go. Then I must make a judgment that agrees with what everybody says so that I may be recognized. I may be accepted. I may be hugged. I may hog the headlines. Judicial independence. Let me move on. Any question? I was talking about impartiality. These are some of the issues that come out when we speak about impartiality. A judge shall perform his or her duties without favor, bias, or prejudice. A judge shall ensure that his, her, or her conduct, both in and out of court, maintains and enhances the confidence of the public, the legal profession, and litigants in the impartiality of the judge and the judiciary. I think Judge Witele has spoken about recusal. He has. I'm not going to speak about that, although I have some, I have some experiences, but that's fine. A judge shall, as far as reasonable, conduct him or herself so as to minimize occasions on which it will be necessary for the judge to be disqualified from hearing or deciding the case. Make a comment on a matter that is pending that might reasonably be expected to affect the outcome of the proceeding or impair the manifest fairness of the process. So as a judicial officer, in order to maintain your impartiality, people might just throw issues at you. There is a judge, Judge Mabel Jansen. Did you hear about her? From South Africa. I wanted to talk about her when it comes to social media. But I think even in this context, it is very, very important. I think someone posted something about the black people and their affinity, if I may use that word, affinity to rape. And she commented that black people, they are just rapists. All of them, every one of these young girls has been raped at some stage or another. This is what she put on, I think it was Facebook. Today she resigned, she's no longer a judge. She was one of the most senior judges because she had this biased approach towards, black people. So what I'm saying is that you must be impartial and be very careful what you say. Okay, I'm now speaking about social media, but it also comes up here because there might be people who put up interesting, you might have a group of lawyers group, whatever, WhatsApp group and wherever. And so, they might, put something that is very tantalizing, something that is very tempting. You also want to make your views known. And that might be kept for some other day, 5 years, 6 years down the line. Maybe you're not even a judge at that point. Judge so-and-so said this. Oh, and you wish the ground will swallow you. You wish you can unsay it. You wish you can unwrite it. But once a bullet is out, it is out. You cannot withdraw it. Well, I think you are lucky because I'm telling you these things. I did not have that opportunity. There are issues that I grappled with, and sometimes you deal with them in solitude. There is no one to ask. There is no one to confer with. But you just have to, and of course, sometimes you learn from making mistakes. It is only, even in 2015, there's a judgment that I really grappled with. And I put it away for some time because it dealt with such a fundamental issue. And you think, what will so-and-so say when they see that I wrote this? You think about all those things. But as I say, ultimately, what we require of you is to deal with the matters in terms of the law. Extricate yourself from your personal beliefs, from your predilections, from your idiosyncrasies, and just deal with the matter purely in terms of the law. But what I will say is that takes time. You cannot easily do it. Because ultimately, a lot of what we are and what we have come to be is influenced by what we have gone through, what we have been taught at home, at church, or the mosque, or wherever else it is. It's a very, very difficult thing. But at least what we can do is to alert you to it so that you know how to navigate around those issues. So that you might find that personally you do not identify with the judgment or sometimes with the result as an individual, but in terms of the law, you might find that you are correct. It's a very difficult process, but it has to be done and it is necessary. Because we must understand that we do not judge ourselves, but we judge other people who believe differently, who have been raised differently, who live differently from ourselves. So one of the things, for instance, that shocked me, I've had the privilege to work in Botswana, and now I'm in Namibia. One of the things that I have to learn is to be accommodative. I come from a very, very traditional society. There are things that are just not done. A man cannot walk into a house like that gentleman there, and you come and you are wearing a hat. To me, it's one of the highest signs of disrespect. But I've got to learn that in other societies, it is not so. So I have to be accommodative and abase myself to what happens elsewhere. I was doing one of the Herero cases, and men came there, they were putting their heads, particularly in court. With us, if you walk into a man's home, not even house, home, when you enter the yard, you take off your hat because the Umnumzane, the owner of the homestead, is the only one who can do it. Not everyone. Even me, my home is not mine, it's my father's. So I take off my hat because I respect my father. and my sons in their homes will not put on a hat because it is their home, it is mine, they respect me. But when you move on, you need to understand and change. So I think that that is one of the things as a judicial officer you need to train yourself. Be able to accommodate others who believe differently from you, who live differently from you. One of the things is, with us, you don't give or take with the left hand. Never. It's a higher sign of disrespect. So here I go to the shops and they give me change with the left hand. I just say, ma'am, please just put it on the counter. Yes, I mean, but I'm learning. Because if I say, no, they believe differently, they've been raised differently, so I cannot now start imposing my Swaziness on this Tamara lady, you know? So I think this is one of the things about the judicial office. You need to change. You need to be malleable. You need to be accommodative of people who see things, who live differently from you. And know that they're as much human beings as you are in your own belief. But then the other thing, which is very important also, is that you also might need to strike a balance. Because let me speak about rape. You might find that there are some cultures where things like incest are allowed and everything. And in that context, you then have to lean in favor of the law because there are some customs and traditions which go against the values that are espoused in the Constitution. You then cannot say, oh, this is what you do in Herero culture. Go ahead. If you want to sleep with her, do it. I cannot interfere in your culture. No. So I'm saying that there must be that balance where it is something that does not in any way offend the law, but offends your personal convictions, lean in favor of the law. But where the law says this culture is bad, it is not right. I mean, there is a judgment I issued in Swaziland some years back. I think in our culture, we have got two marriages. There's customary marriage, and then you also have civil rights marriage. So in terms of the customary marriage, if I have a girlfriend, she might be visiting me, and then me and my family, we start concocting that to this weekend we are going to marry her. So all they do is there is a substance called red ochre. So maybe she comes, she's there in my bedroom at 4 a.m. My sisters and aunts come singing. They get her out of the bedroom, take her to the kraal. They sing, she's smeared with red ochre. They slaughter a goat, and all the processes go. Then she's married, just like that. You can't say, no, it's our culture. That's what I've been trying to teach you. So that's it. And then all the payment of lobola and other things, those are things that follow. But already she's married. And what they do is that they take part of a goat and take it to her home. And then they just throw it there and they say, she's at the Masugus in such and such a place, so that they know their child is not disappeared, but is now married. And then formally, she'll be brought by my people back to her family. So a marriage is done. So, but what happened in this case is that there was a police officer who had a relationship with a lady who was a teacher. And that relationship ended about 2 years previously. And one day she was walking on the road home, and a police van came. And she was loaded into this van and taken to the former boyfriend's home for the weekend, and they performed this ceremony on her. And, she was in Comunicado. There were no cell phones, I think, in those days. And, she was locked up in the house, and, they performed the ceremony and everything, and then she went back home. And then she brought an application before me for annulment of the marriage. And I took a position, and I said, the status of marriage in any woman's life is very, very important. She must prepare herself and tell herself that now I'm going into marriage. You cannot be bamboozled into marriage over one weekend where you think you're going to see your sweetheart. and you come back a totally changed person in status. You need to get yourself ready emotionally and otherwise to get married. And then, these had some knocks on the traditional structures, because there they just go and marry. Oh, I want this one, you marry them. And, so I had to, say something about it, which will have to change the manner in which culture is performed and done, and align it particularly to the principles of the law. We didn't have a constitution at the time, at least not the one that we have. But you had to align those things with what the human rights culture and legal propriety, if I may call it that. So I think in doing this, we must strike a balance between extricating ourselves, but even though we respect other customs, where those customs seem to clash with or collide with constitutional principles, human rights, then the human rights, the Constitution must stand supreme, and every culture must align itself under the Constitution. Let me proceed. I wish I had the whole day, but I don't. I hope you are learning. But it's such a long, I wish this was on Thursday, and then I could do these ones today. Okay, there's the other one, diligence and competence. Article 12 talks about competence before an independent, impartial, and competent court. So one of the core values is that of diligence and competence. And according to the Bangalore principles, judicial duties should take precedence over all other activities. I had some friends in Zimbabwe who were both lawyers and judges. And one of the complaints, some of the judges were given farms. And the complaint was that some of their lordships, because of the farms they had, they would be coming to court late, around 11 in their gum boots, because they'd been tending to the fields. And it becomes so easy because you say, no, I'm a judge in my court. I start my court when I start my court. No, that's not it. If court starts at 9:30, court must start at 9:30. You must be there. The judicial office must be what occupies you. You cannot have some other things that go beyond and above and take the place of your judicial duties, however important those things may be to you. And then judges shall devote their professional activity to judicial duties. They shall take reasonable steps to maintain and enhance their knowledge, skills, personal qualities necessary for performance of judicial duties. So you need to keep reading. You need to keep learning. Particularly read judgments. If you're a magistrate, read judgments of the High Court, read judgments of the Supreme Court, because from there you will learn what the new trends in jurisprudence are. And I would also say, please read, we've got Safli. I'm sure you're all aware of it. Are you aware of it? Or some of it? Yes. So particularly because there are links with other, legal information, institutes, Canley and others. And with South Africa, for instance, right on top, there's the list of cases. They just say, what is new? Sometimes you find that there are 20 cases. So you just make it a habit when you have time just to go through, check what the case is about. And I found some very, very interesting cases, some of which I've used in my judgments. And then the other thing is that judges are to keep themselves apprised of international trends in international law, conventions, instruments establishing human rights norms. Sometimes you find that there is a feeling of I do not want to say nationalism, but there is a judgment, a Botswana judgment, Law Society of Botswana and another versus the President of Botswana and others. You'll find it in my paper. One of the judges stated, it was a full bench judgment, he stated that we don't need anything from anywhere in Botswana. Our cases are replete with all the principles that you can think of. So stop citing these international conventions, cases from South Africa, cases from wherever. We are okay. We are sufficient. We are autonomous. There is nothing to learn from anywhere else. Is that correct? Why? I mean, like even in Namibia, section, I mean, rule 1, is it 131? Huh?
140.
No. I'm talking about the rules. There's the one that says, you know, when you rely on foreign authority, you must then certify. I think it's rule 130. 30. Oh, where are my rules? $130, I'm correct. Rule 130. So what do you say about that? But this is different from what I'm saying. Because here, there are lawyers who are in the habit of going to cite cases from other jurisdictions and then certify that there is no authority in Namibia that deals with that particular case, when that is not the case. There is a judgment, actually, that I read dealing with that. But the point I want to make is that you can get so much enrichment, nourishment, and also develop the jurisprudence because of what happens elsewhere. For instance, I mean, you look at the Kenyan election case. The law might be different, but it is going, I mean, electoral law, is being taken further, where you don't just rely only on irregularities and say, oh, if the irregularities do not affect the result, then it's fine. When there are certain constitutional principles which have been violated, because once you overlook that, it means that what it will breed is a culture of saying, even if you breach the Constitution, it's fine. It doesn't matter. The constitutional principles are there, but if their violation does not affect the result, it's fine. We can violate the Constitution. So there is always a lot to learn. And I think there is a lot to be gained from looking beyond our borders. Because there are certain trends, there are certain, there are certain, I mean, for instance, there's one case that was decided by Judge, she was acting from Marienthal, no, from Kietmansup. Yes, on malicious prosecution. She has extended the meaning of malicious prosecution to say, even if at the commencement of the proceedings, it might appear that there is a case against an accused person, if during the proceedings it becomes clear that there is no case, but the prosecution continues, then it becomes malicious. So we need to look at what is happening in other jurisdictions and enrich our own jurisprudence in order to ensure that we extend justice to those of our people who would otherwise not be, not be eligible, so to speak, to get that. Okay. There's no time anymore. How many more minutes do I have? Ooh. Sorry? Time is up. Okay. 5 minutes. Okay, the other one is equality. I'm not going to go into it. And then propriety. Oh, my. Let me just now I'll leave the core principles because they are there. One of them is judicial. I think I need to speak about judicial accountability. Judicial accountability is the other side of the coin of judicial independence. You cannot be independent without being accountable. One of the most amazing pictures that appears when you talk about judicial independence and judicial accountability happened in Kenya. The Kenyan Constitution of 2010, one of the things that it did was to establish a committee that was going to vet judges. It was a vetting board. They were vetting judges and magistrates over the previous years to see how they had performed. And I think must have been over 100, close to 200 judges and magistrates were fired. because of what they had done. They were given an opportunity to come and they were heard. And so what the judges did was to challenge the constitutionality of this vetting board on the basis that it is challenging or is violating judicial independence. We are independent. You can't peep under and see what is happening. The judicial veil covers everything. So once you want to lift up and pierce the judicial veil for purposes of judicial accountability, you are violating judicial independence. And the court came out emphatically that these principles go together hand in hand. You cannot have independence without accountability, because judges or the judicial office is said to be one of the most accountable offices. Why? Because judges sit in the open, they render judgments in the open, and therefore, in fact, they say that justice is not a cloistered virtue. Everything that we do must be transparency and accountability, so that if something goes wrong, people should have a right to go and complain about what is happening that is not correct. So, but you will find something about judicial accountability. I find that it is very, very, very important. Which goes on, I think, in our Code of Judicial Ethics. In Swaziland, for instance, in the Constitution, there's a provision which calls upon, all the high-ranking officials, including judges, to disclose their assets. I think it's every 2 years. You have to, and that is part of accountability, so that you know how you drive that road. What is it? Range Rover. Yes, whether your means, are there no other, issues that come and enable you to drive it when otherwise to check your standard of living, all those things, and that is part of accountability, because if the judiciary is accountable, then there is respectability that attracts to the judicial office in the eyes of the public. So, and you might say, no, I'm just an individual judge or magistrate. I can do what I do. There are so many magistrates in this country. So what I do alone in my corner shouldn't matter, but it does matter. In our language, they say, "Tifanga mvuyinye." Sheep. When one sheep, unfortunately, whether there are 100 is sheep, when one sheep crosses the road, what do the others do? They follow and they die. So in our language, they say they all die because of one that crossed the road. So that is what happens with judicial office. Your conduct as an individual magistrate, individual judge, individual lawyer matters in the whole general scheme of things. You are not unimportant in your conduct and your behavior. Okay, and now there's relationship. I'm out of time. There's relationship with legal practitioners. Everything will be in the paper about that. That you have to be very careful. There are people you went to school with. There are people who maybe you worked in private practice with. So you have to be very careful how you maneuver, how you interact with them. Do it in such a way that it does not serve to cast doubts or feelings of impropriety over the performance of your judicial duties. Of course, there are extremes. There are some people who think if there is a case that I'm doing with a lawyer in court, then when we meet, we just look away, you walk like this. No, it shouldn't be. You have to be civil to each other, but you should also be careful not to enter forbidden territory because in these matters, I think what is important are perceptions. Which is even in the issue of recusal. It is not reality. It is perceptions. Just ensure, because once it becomes a perception, it may become a reality. So be careful about what perceptions are created by the way that you interact or deal with other people, so that people do not then tend to think, there's something fishy here. So be very careful about that. And then in the conduct of proceedings, one of the things that we must know is that courts are there to serve members of the public. as judicial officers, we have to be courteous, we have to be respectful, we have to be punctual, and we have to treat people with equanimity. You are not a lord in your court, and you start barking and insulting people, knowing that they have no remedy. No, you do not do that. There is a case that I cited here. I think there was a magistrate called Shanika. Is it Shanika? Yes. Where there's a person who appeared before her. I think it was a maintenance issue, and she started raising issues. Oh, you are sleeping with so-and-so. So-and-so has some disease. I wonder if you don't have it. And she went into all sorts of, yes, I've cited the case. And the magistrate was sued for defamation successfully. So as judicial officers, we have to be courteous. I told Ms. Shomani, and I said, when in court, when witness, because when people come to court, some of them are terrified. They've never been there before. You say, raise up your right hand, they lift up the left. Because it is such a traumatic experience. So I told her, when a witness comes in, greet her. Good morning, ma'am. Good morning, sir. Good afternoon, sir. That will do a lot to a person to relax them. So as judicial officers, we must not cause these people to be anxious, to be confused by the manner we keep barking at them and all. No, that is not correct. Even our Code of Judicial Ethics talks about that. And one of the issues is punctuality. I always say, don't be the preacher who says, don't do as I do as I say. As a judicial officer, do first and let others copy you. And also in issues of dress, I get very, very disappointed. I do not know about judicial officers in general. But I see the lawyers, some of them. I'm not sexist at all, but particularly lady legal practitioners. Some of them, the way they dress is so embarrassing and is so disrespectful, not only to them, but to the entire, profession. Some of them, you see them wearing these tight, pants and boots as if they are going horse riding. No, seriously. Because I know that if you are a legal practitioner, there are men who do not like women wearing dresses, particularly but that I have no problem with that. But if you are wearing pants, let them be a suit, formal. Yeah. And then you find some of them, their shirts, the white shirts, hanging all over. No. We have to be exemplary, because in the manner in which we dress, we bring dignity, we bring respect to the court itself. So we have to be very, very careful about that. And then also, one of the things that can get trying is we need to exercise patience and self-control. Shomani, you know what happened a few weeks ago. When I was tried by one legal practitioner, beyond the elasticity of my patience, I just did not understand, and this legal practitioner persisted. But I just decided, let us go into chambers, let's cool down. What is the problem? We resolved it, we're able to go back to court. So there are instances where legal practitioners might trick you into reacting so that they can get you to recuse yourself for whatever reason. There's one case I was handling in Botswana where it was a case involving a lawyer. This lawyer he was struck from the role. In fact, there was an application to have him struck from the role because he was running business and he was, running a law office, undercover, no trust account and everything. So the matter came before me, and we dealt with it. So this lawyer then says to me one day, he says he wants to see me in chambers. I go to chambers. When he gets there with his colleague, of course, he says, Judge, I feel that you are making rulings in favor of my colleague, and so I think you should recuse yourself. I said, okay, one, have you discussed this with your learned friend? No, I have not. Go and do it. Two, is it you or your client who's saying this? He wasn't sure. I said, go and find out. When he came back, he came and said his client says he leaves it in his hands. So I'm saying you are the one who's going to decide. And I told him, sir, no. This order I made in your client's favor, this order I made in your client's favor, I have no reason. I have no reason to make any unfavorable order. I have no friends or enemies in this country. So whatever I'm doing is on the basis of the law and how I understand it. So he said he understood. We proceeded with the trial. His client was his back was against the wall. And then on the date when I was delivering judgment, he did not come to court. He then wrote a letter. It was addressed to the president, addressed to the chairman of the Anti-Corruption Commission, addressed to the Chief Justice, the Judicial Services Commission, everybody of note. And I had to instruct a firm of lawyers. And the Chief Justice, fortunately, took the matter up very seriously. And, he said, if you have any problem, you must file an application for recusal. You cannot just go and make, scurrilous allegations about a judicial officer, and I'm not going to allow it. And what did he do? He then sued the Chief Justice, because the Chief Justice wrote him a letter. He sued him for defamation. So that was the character I was dealing with. And the Chief Justice said to me, Judge, he says that you are firm. So he wants someone who's going to handle him with velvet gloves. And I'm not going to allow it. So there are those who may test your patience in order to get you to lose your temper, such that you then have to be removed from the case for other reasons than issues of competence or even of partiality. So you really have to be very careful. Try and keep your emotions in check. I normally say, once a tail wags the dog, then there's a problem. The dog must wag the tail. Decide when, how often, left, right, up, down, the dog must decide. But once it's the tail that is wagging the dog, you find the dog like this, then there's a serious problem. So it must be with our temper. As judicial officers, we must keep our tempers in check and ensure that we do not treat people in a manner in which they should not be treated. And also speak as little as possible. There is a case, I'm trying to find it. Once I do, I'm going to give it to you. The case went to the Supreme Court of Appeal. It was a case dealt with by one of the judges of the High Court. And they had to go for an inspection in loco and all these things. And when the matter came on appeal, the Supreme Court of Appeal complained that of the entire record, a third of the record, the judge was speaking. He was answering questions, cross-examining the witnesses, and he initiated an inspection in loco, and he was taking pictures at the inspection in loco. He took a very hands-on a very hands-on position, which should not be the case. So I think we have to be very, very careful, speak little, and one of the things which I've taught myself to do, unless during a trial you are asking questions for clarification, which need to be asked there and then, wait. Allow the process to finish. When re-examination is done, you then ask your questions. And having asked those questions, give the lawyers an opportunity to ask if there are any questions that arise from the questions that you ask. Do not assist the parties by putting questions which place someone in a corner. A judge Witele was telling me about one interpreter who was doing so. In interpreting, was actually cross-examining. And when the judge said, he said, no, wait, your worship, I've got him in a corner. So please, do not build cases for people. Do not put someone in a corner. Even if you can have, views about which way the trial is going, but do not be seen to be assisting or cross-examining the parties. And also, during proceedings, ensure that you are even-handed, you are in charge of the court. And do not allow, there are people who bully witnesses in cross-examination. It is your duty to ensure that all the rules are observed. There is a judgment which was delivered by Madam Justice van den Heever, where she says, cross-examining does not mean examining crossly. And the judge must ensure that the cross-examination is used for the right purposes. Witnesses are not bullied, they are not insulted, and the court must be in charge of that process. Unfortunately, I've run out of voice and I've run out of time. But thank you for your kind attention. I hope you learned one or two things. Thank you very much.